Good morning, all. So, SEBI exam has come very nearby, and ixamBee has come with an innovative thinking about what in what way we can help you when exam is actually nearby and stress level is very high. So, we thought of coming up with a series of live sessions that will be divided into three parts. I have picked 50 most important questions for legal paper for SEBI that can be asked. Obviously, the questions cannot be same exactly, but the areas which hold importance and the way questions can be asked, how tricky the questions can be. So these tips you can get by having a look at this video and with this session and this PPT. So starting with the most important questions, part 1, I would like to deal with the very first question that I have picked. That is from constitutional law. The key to the minds of framers of the Constitution is stated in what provision? Now here I want to know by this question the key to the minds of the framers of the Constitution. So the options for this question will be Part 1 of the Constitution, Directive Principles of State Policy, Article 32 of the Constitution, Article 21 of the Constitution, or Preamble to the Constitution. So what do you think? Even I expect everybody to just be interactive in this session and just post your answers in the comment sections. And please be quick because I want quick answers. I hope you all must be quite prepared up till now. And you must be revising your content. So you should know the answers. Quickly, or else I'll let you know the answer. Nobody? Okay. So the answer is E, that is Preamble to the Constitution. Yes. Yes. Preamble is the key to the minds of the framers of the Constitution as it envisages the goals to be attained and effective interpretation of the preamble. So it can help us read the minds of the framers at the time the Constitution was drafted. Though fundamental rights, Article 32 holds a lot of importance in the Constitution. But when we are thinking about interpretation perspective, then it has to be preamble because it discusses the goals that were set in the mind of the Constitution framers at that time. Okay. Now going to the next question. Question number 2. Situation based questions are also expected a lot in competitive exams. So let's have a look how these questions can come. Akhil draws a picture of Suresh running away. So the answer has to be C. That is defamation. According to section 499 of IPC, which defines defamation, Akhil has committed defamation provided that his act does not fall into any of the 9 exceptions that are provided for defamation. Okay. Now let's quickly go to the next question. Question number 3. That has been picked from Companies Act. Companies Act 2013 provides that the board of directors can appoint additional director if such power is conferred on them by the. Now which provision here they have basically asked that Companies Act 2013 provides for board of directors that they can appoint an additional director also. So if such power is conferred on them, then that will be conferred by the options are articles of association, memorandum of association, shareholders, both articles of association and memorandum of association, and or else all of the above. So, what can be the answer? The answer has to be A, that is articles of association. If you look into section 161 of the Companies Act that provides for additional directors, the board of directors can appoint additional directors if such powers is conferred on them by the articles of association. So such additional directors hold office only general meeting or the last date on which the annual general meeting should have been held. So whichever is earlier. And a person who fails to get appointed as a director in a general meeting cannot be appointed as an additional director. So questions like this can also be asked. So you have to remember things conceptually, that articles of association provide for all these powers that can be conferred on for appointing additional directors. So in such way questions can be posed, and company law of course holds 15% of weightage, so such kind of questions can be expected. Next question: if A is unable to give sureties that are required under section 436 of the Criminal Procedure Code in spite of one whole week time that has been given, then in such a case police officer will do what? Now this question has come from the criminal law, that is Criminal Procedure Code, and a situation has been given. So for this situation is posed on some peculiarities of section 436. If you know this section well, then you can answer such kind of questions. Always remember, when you are preparing such sections which are very important, please note down certain conditions or peculiarities of those sections, so that if questions are posed from such peculiarities, then you are easily able to connect the questions and answers with that. Now let's look at the options for this question. Now in such a situation, the police officer will do what? Cancel his bail and take him into custody, or give him more time as per the facts and circumstances of the case, or presume him to be an indigent person and release him on executing a bond without sureties, or release him on giving surety by himself, ask him to execute a bond after detaining him for 7 days. So these are the possible solutions that are proposed. So what do you guys think? What can a police officer do in such a situation? He is already given 7 days. So what he will do? Let's look at the answer. C. As per section 436 itself, if an accused is not able to produce the sureties within a week's time, then in that case he is presumed to be an indigent person, and the police officer will release him on his executing a bond without sureties, because in such a situation he cannot be detained obviously just for technical issues. So he has to execute a bond without sureties. Coming to the next question, question number 5. Now this is something that we have got from evidence. Very important section of the Evidence Act has been posed here. So under section 32 of the Indian Evidence Act 1872, statement of which of the following person or persons is considered as relevant: who is dead, who cannot be found, who has become capable of giving evidence, whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court as unreasonable. Now this question talks about it's related to relevancy of statements. So they have given that the statement, and now you have been given the provision also over here. So if you have read 32 well, then you can quickly answer such kind of questions. So the options will be only one and two, 1, 2 and 3, 1, 2 and 4, all of the above. So for this, we need to go back to the situations. So you carefully look at this at the options here first. That is, which of the following person's statement will be considered as relevant? Who is dead, who cannot be found, who has become capable of giving evidence, whose attendance cannot be procured without an amount of delay or expense. So all these situations are there. So which would you pick? Either one and two, 1, 2 and 3, 1, 2 and 4. 1 is common in all the options. So obviously 1 will be there, because we all know statement of a person who is dead is regarding that dying declaration and all. So the answer will be D, 1, 2 and 4. I have quoted the provision also over here. Section 32 of Indian Evidence Act says cases in which statement of relevant fact by a person who is dead or cannot be found, etc. is relevant. Statements written or verbal of relevant facts made by a person who is dead or who cannot be found, or who has become incapable of giving evidence, or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appear to the court as unreasonable, are themselves relevant facts in the prescribed cases. So the answer will be 1, 2 and 4. That is, person who is dead, person who cannot be found, and person whose attendance cannot be procured without an amount of delay or expense under the circumstances of the case, as it appears to the court as unreasonable. The third option is actually deleted, because someone who has become capable of giving evidence is of course not covered under this section. Such questions are actually easy, but their framing is such that sometimes we get confused, because already we are in such kind of stress level when we are appearing for exam. We don't have much time. So if we are very concrete with the provisions in our mind, and we have solved such kind of questions earlier, then we won't lose confidence while we are solving the questions in the exam. Okay, so let's go to the next question. Question number 6, where lease omits to mention at whose option it is terminable. Now this is a question from Transfer of Property Act. Now in this case, lease does not mention anything as at whose option it is terminable. Then in such cases, the lease will be terminated by, the options are terminable by leaser before expiration, terminable by leasee before expiration, not terminable before expiration, not a valid lease, terminable by leaser and leasee, both with mutual consent. So, any guesses? Terminable by or not terminable at all, or such a case the lease is not valid at all. So the answer will be B, terminable by leasee before expiration. Now always in such kind of situations, the leasee has the choice to terminate and not the leaser. We have a clear-cut provision for that in Transfer of Property Act, that is section 110, option to determine lease. So if you know this provision, you can answer this question within seconds. I told you, I am telling you repeatedly, such kind of peculiarities just highlighted then and there. If you have not highlighted it, and do revise this before you go for the exam. Such kind of situations are having most probability of being asked in the exam, where the time limited is expressed to be terminable before its expiration and the lease omits to mention at whose option it is so terminable, the leasee and not the leaser shall have such an option. Okay. Next question. Now again, a situation based question. We have a situation relating to arbitration agreement, very important part of the Arbitration Act. Questions from this area can be asked. So there is a situation. Let's go through what situation it is. Mr. Anil and Mr. Mukesh have entered into an arbitration agreement for the disputes that arise, if any, in their business transactions. So due to certain fault on the part of Mr. Mukesh, the dispute came before the arbitration for settlement. And in the meantime, what happens? Mr. Anil dies. So in such case, Mr. Mukesh shed off their liabilities on the plea that arbitration agreement has come to an end with the death of the other party. What would be the affirmative statement in the given situation? Now carefully, you all also have another reading of this question. This is a situation that has been posed before us. Carefully try to understand this, then we will go to the options. In this situation, there are two people. They have entered into an arbitration agreement, and while they are having their business transactions, in that course there is a fault on the part of Mr. Mukesh, and dispute has come before the arbitration for settlement, and the Mr. Anil, who has suffered due to that loss, dies. So Mr. Mukesh will shed off their liabilities on the plea that arbitration agreement has come to an end with the death of the party. So in such a situation, what will happen? Let's have options. Arbitration agreement gets terminated due to death of the party, or else it shall remain enforceable by or against the legal representatives of the deceased, or it will be discharged from the assets of the deceased. Both A and C, that is, arbitration agreement will get terminated due to death and it will be discharged from the assets of the deceased person, or none of the above. So you have understood the situation. You have options before you. Think of it for some seconds. What can be the answer? Arbitration agreement. Have you read any provision relating to arbitration agreement? And if one of the party dies, who is a party to the arbitration agreement? Then what can be the consequences? Are you all aware of such kind of situation? Okay. So the answer will be B, that it shall be remaining enforceable by or against the legal representatives of the deceased. LRs of the deceased will come into picture, and arbitration agreement will not get terminated automatically. And we have a provision for this in the Arbitration and Conciliation Act 1996. We have a straightaway provision, that is section 40. An arbitration agreement shall not be discharged by the death of any party thereto, either as respects the deceased or as respects any other party, but shall in such event be enforceable by or against the legal representatives of the deceased. Okay, so this is something which is different and can be tricky if you do not know the clear-cut provisions. Next question. Question number 8. Now this is from securities law, another area which holds a lot of weightage. What is the minimum remuneration of independent directors as per the SEBI listing obligations and disclosure requirement regulations of 2015. So what is the minimum remuneration of independent directors as per this particular regulation? Options will be minimum rupees 15 lakh per annum and sitting fees of rupees 10,000 to 20,000 per meeting. Minimum rupees 25 lakh per annum and sitting fees of rupees 20,000 to 50,000 per meeting. Minimum rupees 10 lakh per annum and sitting fees of rupees 20 to 50,000 per meeting. Minimum rupees 5 lakh per annum and sitting fees of rupees 20,000 to 50,000 per meeting, or else no such limit is mentioned. So the SEBI listing obligations and disclosure requirement regulations 2015 lays down what? The answer is mentioned over here actually. The answer is D. This is something which is not tricky actually. This is a knowledge based question. If you are aware of the regulation, only then you can answer such kind of a question. And if something like this happens, that you are not aware of this provision or else you are not sure and you are not able to recollect it, then don't attempt when such kind of questions come, because you are also having negative marking. Don't forget that in such kind of things you cannot just guess. In such, you will also have some questions which are direct and knowledge based. You can answer only if you are aware. This is not something which you can guess. So in such kind of situations, be aware when you are solving your paper, okay? Because you do not have to just mark everything and then lose marks in negative marking. So D, that is minimum rupees 5 lakh per annum and sitting fees of 20,000 to 50,000 per meeting. This has been clearly provided in the regulations, that is SEBI listing obligations and disclosure requirement regulations of 2015. Okay. Going to the next question, that is from Specific Relief Act, and it is a section based question. As per section 10 of the Specific Relief Act, which of the following cases are specifically enforceable? Now for this we need to look at the options first. The options are contracts for sale of patent right, copyright, rent laws, future property, or else A, B and D. That is contracts for sale of patent right, copyright and future property. So leaving rent laws, all the three options or else any one of the option can be true as per section 10 of the Specific Relief Act, which provides that which of the following cases are actually specifically enforceable for it. Okay. So for that, look at the answer. Section 10, if you are aware of the section 10, you can easily answer this question. E, that is leaving rent laws, everything else is covered. Section 10 provides that the cases in which specific performance of contract is enforceable. It says that except as otherwise provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced when there exists no standard for ascertaining the actual damage that is caused by the non-performance of the act agreed to be done, or when the act agreed to be done is such that compensation in money for its non-performance would not afford an adequate relief. So this can happen in such kind of situations that we have in option A, option B and option D. In such kind of situations, you cannot actually, there is no particular standard for ascertaining the actual damage, and if there is non-performance and the act agreed to be done is such that compensation in money for its non-performance would not afford an adequate relief. For rent laws, the situation is not like that. So you have to apply your mind. If you are aware of the concept well, then you can apply your mind well on the question, on the options as well. This is about Specific Relief Act. Now going to the next question. Question number 10, that is from Consumer Protection Act. As per Consumer Protection Act, a complaint shall be instituted in a state commission within the limits of whose jurisdiction. Now this is regarding Consumer Protection Act and regarding jurisdiction. So quickly you need to relate. So for that, first we look at the options. The opposite party resides within the limits of that jurisdiction, or where the opposite party carries on business, or where the cause of action wholly or in part arises, the complainant resides or personally works for gain, or else none of the above. So which provision you think will come into picture here? That the complaint shall not be instituted in a state commission within the limits of whose jurisdiction? Which provision you think? Because it talks about the complaint shall not be instituted. Be careful. Always read the question well, or else you will get confused where the complaint will be instituted. Be careful, it is regarding where the complaint shall not be instituted. So the answer will be none of the above. None of the above will be the answer, as the situations that are provided over here are all regarding the complaints that can be instituted within these jurisdictions. And they are asking where it shall not be instituted. So like that you have to read the question well and not get tricked. Okay. Now if we look into the solution further, I have quoted the section over here. Section 47 clause 4 of Consumer Protection Act provides where a complaint shall be instituted in a state commission within the limits of whose jurisdiction. Now the options that were given there are picked from this section. So obviously when you are asked a negative question that where it cannot be instituted, then the option will be none of the above. If you know this section, then you obviously have to keep in mind what are the situations when a complaint will be instituted. And then read the question carefully, that what is actually asked, and then answer. Many a times it happens that you are in a hurry to solve the question and then you answer something which is related to this section, but the question is actually a negative question and not directly asking where the complaint will be instituted. So take care of such kind of things should not happen with you while you're solving your exam. Okay, so coming to the next question, administrative tribunals. Administrative law basically you have in your syllabus, and administrative tribunals exercises what? Purely administrative functions, purely judicial functions, purely legislative functions, quasi-judicial functions, or else both B and D, that is purely judicial functions and quasi-judicial functions. Now this is actually a very easy question. If you are aware of why an administrative tribunal is established and what is its purpose, then you will never get confused. Your basics should be actually very clear. But the options are twisted, like they have given both B and D. So many a times we get confused. So we don't have to do that. So the answer for this question will be D. That is quasi-judicial functions. Now it is actually a tribunal. So if we go into administrative law, the tribunal term is used in a significant sense and refers only to the adjudicatory bodies which lie outside the sphere of ordinary judicial system. So obviously the answer cannot be purely judicial functions or purely legislative functions. And technically in India, the judicial powers are vested in the courts. which aim to safeguard rights of individuals and promote justice. So therefore, to institute an effective system of judiciary with fewer complexities, the judicial powers are delegated to administrative authorities. This delegation is provided under administrative law. We all are aware. So if they are delegating the powers to administrative authorities, so that is giving rise to administrative tribunals, because the adjudication of such kind of disputes arising from such kind of powers that are exercised by delegation. So for that we have administrative adjudicatory bodies which hold quasi-judicial features. So the answer will be quasi-judicial functions. So now in this question, not only one concept but 2 to 3 concepts are involved. So you have to apply the law keenly when you are solving such kind of questions. When you look at the question prima facie, it seems to be very easy, but you have to apply your mind and apply all the concepts relating to administrative law that you know over here and keenly answer the questions with care and caution. Okay, coming to the next question. Now, the concept that law is the practice of courts is stressed by the theory of. Now, can anybody quickly say that from which subject we have this question? Quickly. It's talking about a theory of law. Okay. So, it is of course from jurisprudence, and the options will be natural law theory, legal realism theory, positivist theory, comparative theory, none of the above. Now the options are all about theories of law. They are providing different theories of law. So for this you have to know all the theories of law, which is a very important area that is questionable from jurisprudence. So if you are asked that law is the practice of courts, so you should know that what is proposed actually in each theory. In each theory, what is proposed, you should be aware of that. So the concept that law is the practice of courts is stressed by the theory of, the answer is B, that is legal realism theory. Legal realism theory, actually it is the most easy, I feel it to be the most easiest theory of law that is provided by jurisprudence. So legal realism is mainly concerned with the law that is in action, and according to a realist person who propounds the theory, who believes in the theory of legal realism, the judges make law rather than they find it. In the making of the decisions, that is the ratio behind their decisions, that ratio makes the law. So this, many a times you won't be given the exact words that are quoted in that theory. The words can be changed somewhat, but if you know the concept well, then you can answer such kind of questions. Coming to the 13th question. Now it is again from securities law. It holds 15% of weightage, so more questions are expected from this area. The presiding officer of the Securities Appellate Tribunal, SAT, is appointed by which of the following? Now there can be questions regarding appointment. From constitution also we can have such kind of questions regarding appointment. Who appoints whom? So the presiding officer of the Securities Appellate Tribunal, that is SAT, is appointed by which of the following? Options: Supreme Court of India, Reserve Bank of India, Stock Exchange of India, Central Government in consultation with the Chief Justice of India, or Chairman of Securities and Exchange Board of India. So who appoints the presiding officer of SAT? Direct answer D, that is Central Government in consultation with the Chief Justice of India. Again, this is a knowledge based question. You cannot just guess it. You have to be aware of the provision. So just try to read whatever appointments are made by whom, to which post, in such kind of subjects like constitution, securities law. So as per which provision, section 15MA of SEBI Act 1992, central government in consultation with the Chief Justice of India appoints a presiding officer and judicial officer of SAT. So a question regarding judicial officer of SAT can also be posed similarly. This section you should be aware of, so that you can answer at least 2 questions that can be posed from this section alone. Okay. All of you are answering well. I'm happy to see that many of you are well prepared for the exam. Good going. You all are having a good revision with me. So the next question. Which of the following statements is true? True or false questions, assertion reason questions, such kind of questions may be asked. So the first statement that has been posed is central government on recommendation by SEBI, if satisfied, may grant immunity. Second statement, an immunity that is granted by the central government may at any time be withdrawn upon new findings. Third statement, recommendations for immunity by the board is not at all binding upon the central government. All of the above, none of the above. Now this is regarding the immunity, whether it can be granted by the central government, and if can be granted, how. So in out of these statements, now they have made the drafting of the question is such that you should be aware regarding the immunities. Only then you can answer the question. If you are going to guess, then you will get confused, because all of the above and none of the above is there to confuse you enough. Okay, so the answer will be D, all of the above. Now if you know the provision, section 24B of the SEBI Act, which clearly describes that central government can grant immunity on recommendation of SEBI, which is not binding, and the immunity can be withdrawn upon discovery of new evidences or new findings. So basically what is done here, this section itself has been broken into 3 statements. So all the 3 statements are actually true because they are part of the entire section. So this is an important section. If you are aware of this, then you can solve the question easily. There's no chance of you being confused. So just keep in mind such things. Next and the last question for today's discussion. I will be covering 15 questions today. And the last question is, which of the following schedules of the Companies Act 2013 deals with the format for the preparation of financial statement of a company? Schedule 1, Schedule 2, Schedule 3, Schedule 4, Schedule 6, Schedule 7. Okay, so this is also a very direct question. Like see, SEBI has a pattern of moderate, difficult questions. So you should be mentally prepared for easy question, for difficult question, or moderate question. Some questions can be very direct and easy to solve also. Okay, and moreover it depends upon your study and your preparation, that a question is difficult for you or easy or moderate. It depends upon your preparation also, how well you are prepared. So the answer for this question has to be B, that is Schedule 3. Section 129 of the Companies Act deals about the financial statements should give a true and fair view of the state of affairs of the company or companies that comply with the accounting standards that are notified under section 133 and shall be in the form or forms as may be provided for different class or classes of companies in Schedule 3. Okay, so it directly provides that financial statement that is prepared for a company that has to be facilitated by Schedule 3. Okay, this is something which is an important area again from the Companies Act. So such kind of situations, such kind of questions, you have to take note always, keep them marked, revise well before you go for the exam. Okay, so in today's discussion, I had brought for you all 15 questions. Now we will have similar 2 more sessions to cover total of. In the next part, that is part 2, I will be covering another set of 15 questions on a priority basis so that we can cover every subject, but according to the subject weightage priority, of course. And we'll discuss another set of 15 questions that hold importance. Okay, till then, study well, be well prepared. Don't get stressed out, exams are near, but of course, we will be meeting and having a good revision. Carry on your studies well. And one more thing I would like to tell you, as it is in a festive mood, that Christmas is nearby. So we have a Christmas gift for you all, to the subscribers of ixamBee. And if you all are interested, then you can get yourself aware of the offer that we are having for Christmas. You will be getting discounts up to 30% on all the courses. So just quickly visit our website and unwrap your gifts as well. Okay. Okay, stay safe, study well, best luck. Have a good day, all of you.